Good morning again. As you can see, we have reconstituted our panel. I remain Judge Rubin, and I am honored to be joined today by, to my right, Judge Henry, my left, Judge Hand. We will hear the two remaining cases on the calendar. The next one is a partially impounded case, so I will remind counsel not to violate the impoundment order with whatever you may say here. We will certainly not use the name of the person whose guardianship is at issue. It is number 22449, Department of Mental Health versus, at least this is the way I have it, versus, why don't I just say person. And, I guess initials are what, you'll know what's appropriate, I don't. It's 15 minutes aside. There is no rebuttal, as Judge Mead described at the beginning of the session. And we will hear first from Attorney Nering.
May it please the Court, my name is Ilse Nering, and I represent And the guardianship must be vacated because WT's decision for treatment with Haldol did not demonstrate his inability to meet his essential requirements for physical health, safety, or self-care. And contrary to DMH's assertion, his decisions about the lesion and about his obligation to register were irrelevant because in the order and decree, WT retained his right to make or communicate routine health care decisions, to manage his medications for his physical health, and retained his right to seek legal counsel to determine in court or before the SORB whether or not he had an obligation to register.
So, counsel, I just want to ask a preliminary question. I want to make sure that I understand the scope of the guardianship. Is it limited to antipsychotic medication, or do you think the guardianship is broader than that?
I think if we look at the limitations of the guardianship, so the judge has checked off that he cannot smoke and certain things. He cannot vote. He lost his right to vote, and certain things like that were checked off. But so,
well, what I'm really trying to understand is he making medical decisions about the lung issue, or do you think the guardian is making those decisions?
I know that he's making the decisions.
Okay. So
have you been in recent contact with your client?
I beg your pardon?
Have you been in recent contact with your client?
I can't understand the question.
Have you been in recent contact?
Yes, I have, Your Honor. I spoke to him on the phone in January, and he's here in the courtroom.
Oh, all right then.
So, for years, WT has been deciding for his treatment with Haldol, and DMH never questioned his capacity to make that decision. Even at times when he was psychotic and delusional, they never sought a guardian. And in April 2019, they determined that he had the capacity to enter into another second conditional voluntary study.
When a person declines medical treatment, never mind antipsychotic medication and Rogers, a person in custody of DMH under one of these conditional voluntary admissions refuses medical treatment, let's say life-saving medical treatment or obvious medical treatment, and does so without the kind of explanation that we saw in that other case about the amputation, no good reasoning, does DMH ever seek a guardianship? Or only for antipsychotic medication?
I cannot answer that question.
No, I'll ask your colleague on the other side that as well. Have you ever seen such a thing?
So, if I understand the question correctly, if the probate court determines that the person lacks competency to make an informed treatment decision about their physical health, can that be a reason to order and
to appoint a guardian to make the decision or implement the decision about physical health?
Of course, that would be a reason. I mean, we look to the guardianship of BVG, and when the respondent is unable to make a decision about a personal medical problem, and that's resulting in an inability to meet an essential requirement for physical health, then the court can appoint a guardian to review all the circumstances and make a decision to alleviate that problem. But that's not what happened here, because WT retained his right to make...
No, I understand that's not what happened here. That's what I'm trying to figure out. So now we have a judge making a finding of incapacity. I know that he uses the word incompetence, but for the moment, let's assume he found incapacity within the meaning of the statute based on reasoning about physical health decisions of some seriousness. Can that be broad enough? I know there's a separate inquiry, but he finds the incapacity extends to personal decisions, business decisions, medical decisions. Can there be something that a respondent, I guess he's a respondent, does that allows a finding that broad? Or does the judge have to find, he made a bad decision about business, so now no business. He made a bad decision about physical health, so now someone else has to do that. He made a bad decision about whatever. Or can there be a finding based on action in one area that's broad enough to cover everything?
No, I disagree with that, Your Honor, because it used to be that one uninformed decision made a general guardianship, but that's not the way it is anymore. That the purpose now is to have a limited guardian, and the guardian's authority is confined.
But you can imagine someone saying something like this. We told him not to go on the roof, and he said, I can fly. And then later we said to him, you can't get in that golf cart. And he said, it doesn't matter, I'll just make it fly. And he's delusional, believes he can fly. And so the judge finds, that's not a person you can have making any serious decision as long as they continue to believe they can fly. Right? Would that be okay?
Okay, to appoint a guardian for all purposes?
Subject to the subsequent question about competence to make informed consent choices about antipsychotic medication, yes.
So if the evidence establishes that the person is on a roof and continually is going on the roof and wants to jump off the roof due to psychotic delusions, then, it is that he's unable to meet his essential requirements, and therefore the guardianship would have to be crafted. But then it seems there the problem. So it's but it is resulting in the inability to meet the essential requirements for physical health, because his life is at risk and endangered. And therefore, the refusal to take antipsychotic medications does result in an inability to meet the essential requirements for physical health.
There has been no finding that antipsychotic medication would help this. Right? He's just incompetent. Not incompetent, incapacitated. I'm just trying to figure out if you can ever have a finding of a kind of pervasive incapacity that then allows the judge to craft narrowly, of course, an order in a number of different areas. He thinks he can fly. Let's not let him write any checks on his bank account right now while he thinks he can fly. Let's not let him... I don't trust his decision-making ability. So I don't think things that are important, let's not let him sell his house right now. You see what I mean?
Yes, but respectfully, under the MUPC, it's not about trusting the quality of the person's decision-making. It's about the decision-making to such, the condition affects the decision-making capacity to such an extent that the person lacks capacity to meet these enumerated essential requirements.
So I want to understand, it seems like you're arguing the court, two different things, that the court applied the wrong standard, but even if they applied the right standard, there was not sufficient evidence. Is that right?
Correct. That the evidence under the MUPC is extremely clear. I mean, the words of 5-1019 are very explicit, and informed decisions is not a requirement. But if it is a fact in the case and it becomes relevant, nevertheless, even an uninformed decision does not necessarily mean to appoint a guardian, because even if a person makes an uninformed decision, they can still be meeting their essential requirements for physical health, safety, or self-care.
So you recently argued a different case to this court, and I believe we have not issued a decision yet. That's the CA case. What I'm trying to understand is how that case is the same as or different from this case.
Right. In that case, I think part of it is that there was actually no finding that the person was an incapacitated person as defined by 5-1019, but the court concluded that nevertheless, the decision the judge made tracked. Whereas in this case, I have laid out how the evidence was insufficient to ascertain, to make a finding, was legally insufficient to determine that the schizoaffective disorder bipolar type resulted in the inability to receive and evaluate information or make or communicate decisions to such an extent that he lacked the ability to meet his essential requirements for physical health, safety, or self-care.
Do you think that as long as he was compliant with prescriptions, that's the case? That is, I find, and again, I'll ask opposing counsel about this, he was doing what they recommended. He was, in fact, deciding to follow their recommendation. And yet the court finds he lacks the capacity or competence to make informed choices about the medication. And at the end of the day, I'm left with an order that looks as if its whole point is, if the hospital wants to give him an injection instead of his preferred oral route, they can. And I wouldn't think that's what you appoint a guardian to do if both are equally efficacious.
The guardian can't make the decisions about the antipsychotic medications, if I understand.
Well, the judge is going to approve a treatment plan, as he did, that uses this wiggle word about if possible, but you know about that, at the sole discretion of the doctor, whether to do it by injection or otherwise. And I'm just trying to sort out, you say his decision-making about the lung cannot mean, frankly, I think, of course it could mean he lacks capacity to make an important life decision for his physical health. I mean, I don't know what you know what I mean? I'm not a doctor, and I don't know if we even have all the medical records, but I understand how a decision about that could lead to someone saying, and so we're going to appoint a guardian. And here's the treatment plan I approve. I don't know if you need that for physical health. And it is, go and get a PET scan or whatever. You know what I mean? Like, let's see what's going on here. I get that, but what I'm saying is before you can say he is incompetent to make decisions about antipsychotic medication, do you have to show that he has made a poor decision about antipsychotic medication. I know there's some evidence that at some point he stopped taking the oral pills, but at the time of trial, that's not the circumstance.
No, and even before they petitioned for guardianship, he was taking the medication.
Yeah.
And in order to appoint a guardian, the decision about the antipsychotic medication must, in the end, if they want to appoint a guardian, demonstrate that that decision is resulting in an inability to meet these enumerated essential requirements. And it's physical health, not mental or psychiatric health. My time is almost out.
Do you know how your client is receiving Haldol right now?
Do I have what?
Do you know how your client is receiving the medication right now, orally or by injection?
Right now, I believe it's by pill form still. I think it's the last I knew it was by pill form.
Okay.
Do you have, I know you have no time left basically, but do you have any concern, or is this case at all about who this person is that they've picked as the guardian, who I gather has never talked to your client? I don't know if they're supposed to or if they're just doing a ministerial act.
I mean, what is the guardian actually doing now?
Well, I mean, is that part of this case at all? Like this stranger to everyone, or maybe she's not.
I don't know what the guardian's doing right now.
Okay.
I'm sorry.
No, that's all right. Thank you very much. Very, very helpful argument to us. This is a complex and developing area of law, and your assistance is really appreciated. We will hear next from Counselor Weitzel.
Good morning. May it please the Court, Richard Weitzel, Assistant Attorney General for the Department of Mental Health. I might start, if I could, with Justice Rubin's questions around the scope of a guardianship order and sort of the question of can that order encompass, and I don't mean to misstate your question, but can it encompass sort of multiple dimensions? And I think if I could, I think you sort of have to, I think the answer is yes. I think you need to sort of track the various guardianship provisions. Obviously, Section 5-306 allows for the appointment of a guardian if a person is incapacitated. That word, incapacitated, is, of course, there's a definition in 5101 subsection 9, and it encompasses, as I think the Court knows, physical health, safety, and self-care. It's very broad. So I think once the trial court finds that there is grounds for a guardianship, that guardian does have broad powers. It's limited by whatever's in that limitations document that was part of the trial court's order, but I think 5-209, 5-309 in the statute.
So in this case, the basis for the finding of incapacity is the decision-making around the lesion on the lung. Is that correct?
I think that's one basis.
But without it, do you think, I mean, it seems like one, yes, but an essential one for the judge's reasoning. Like if we knock that out, presumably we'd have to send it back because who knows if the rest is enough.
I don't think that's so, Your Honor. I do agree it's certainly something that the court emphasized, pointed out, but the trial court also credited the expert's testimony that the patient generally
has cloudy thinking around treatment decisions. I'm not going to affirm appointing a guardian for someone with cloudy thinking around treatment decisions. Because half the people in America would have a guardianship. Cloudy thinking doesn't seem adequate to show incapacity. Do you think it does?
Well, I think it's more than that. I think it's due to his mental illness he has poor insight, into the fact that he has...
Adequate to a point, so it's incapacity. Everything's going fine so far, but we think something could happen bad later. Here we are. Let's take away this person's right to autonomy about their medical decisions in their body. I just don't see that.
I don't want to argue with you, Your Honor, on that.
All right.
But the reason I say that is because I think there is specific evidence in this case that goes beyond that.
But I don't think there are findings that go beyond that. There may be evidence, but we're reviewing findings, right?
I think the findings are certainly important, but I think the court can review the totality of the evidence.
And de novo say that a guardian should be appointed? How would we weigh the credibility of the psychiatrist who testified? How would we do that?
Well, the psychiatrist, it's on the record that the psychiatrist met with this individual every week. He's been doing that for 3 years.
You put in evidence that he couldn't make decisions about the lung, right?
Sorry?
You put in evidence, it's your burden, that he couldn't make decisions about the lung, and that was endangering his physical health or safety, right?
Yes.
But you didn't seek a guardian for that, did you?
That was not the original...
I'm not interested in that. I'm asking if you sought a guardian for the problem that you identified.
I think at the time of the trial, which is sort of the operative time where the court should consider the guardian, that was part of the reason for the guardianship.
And yet, the order itself says that W can continue to make the treatment decisions about the lung. Does that not undermine the conclusion, the alleged conclusion of the judge?
I didn't catch the question. I'm sorry.
The respondent is allowed to continue making medical decisions about his physical health under this order.
Or do you disagree with that?
I don't agree with that, Your Honor.
It says routine medical decisions are up to him. There's nothing in the order. There's no treatment plan. There's nothing about the lung lesion. Do you think the guardian can make the decisions? The court? Who should be making those decisions now? And frankly, who is making them?
Okay. Well, first of all, I think the guardianship order itself and the limitations document speaks to routine medical decisions. And I think this falls outside.
So you think that the guardianship means he can no longer decide whether or not to have tests for lung cancer?
I think the guardian can fairly provide input and maybe...
Input. I'm asking who makes the decision.
I think the guardian can make the decision around whether there should be further testing.
Okay. Where in the order would I find her authority to do so?
I think it lies within the fact that the guardian has been appointed and within the statute. The statute.
Look. There's a detailed order of what she's allowed to do.
I don't agree. There's an order that a guardian's been appointed, and then there's a separate limitations order.
Right. So I think if I understand you, I think you're looking at RA1, page 20, which refers to the statute, and you're really relying on section 5-209 and 5-309 for the specific authority of the guardian. I don't see anything in this record that says the guardian can make any medical decisions about the lung lesion. So you've got to be finding that authority somewhere else.
I think it's
we don't know where, though, and that's what we need you to tell us.
Well, I think by the statutorily, when a guardian is appointed, that guardian has all the powers that are in 5-209 and 5-309, subject to the limitations document, the limitations page. And I think here it's notable that what was carved out was a reference to routine medical decisions. And I think from the language of the...
I'm sorry, I'm looking at the limitations to guardianship. I don't know whose form this is, but it might be the court's, it might be yours, I have no idea. Medical decision making and management. He's allowed to manage medications, excluding antipsychotic medications. He's allowed to make and communicate routine health care decisions. And then the other two have nothing to do with cancer treatment or testing. Choose a long-term care facility, choose a home health care provider, whatever. So I don't understand how you think this says he's not allowed to make it. And P.S., I don't know, but he's in your, I don't know if it's technically called custody, although it does take 3 days at least to get out, et cetera, et cetera. I'm guessing you're letting him make the decisions, like you did for 2 years while he lost 110 pounds. Don't you think that's right?
Well, Your Honor, I want to respond to the first question, which is the basis of the guardian's powers here is not RA 23, which is the limitations to guardianship page. Those are the carve-outs. And if you look at...
But there is no carve-out there listed that would cover decisions about testing for cancer except the check boxes that are there.
Well,
and since presumably... Well,
no, go ahead. No, go ahead.
No, and presumably sometimes someone needs a carve-out for things like that, and sometimes they don't. And all the judge can do is check or uncheck the box. So I guess if they wanted to make sure, if a judge wanted to make sure that no one misunderstood and that the decisions about cancer treatment were to be made by the guardian, or I don't know if it's actually made by the court and implemented by the guardian, I don't really understand how that works. Presumably they would not check this box, or they would check the box and say comma, like it did below, except for the terribly scary and possibly fatal disease that remains untested and untreated. And you didn't ask the judge to, and the judge didn't do it, and I'm having a hard time understanding
Your Honor,
how this is about something more than you want to give it to him Haldol by injection, and he wants to take it by mouth because he's fully compliant with the doctor's recommendations at the time of trial.
Okay. Your Honor, first of all, the guardian's powers, I don't agree that the guardian's powers have to be spelled out in particular form. The guardian's powers are governed by the statute. The record here, the decree appointing the guardian, says that the powers and duties of the guardian include all powers authorized to a guardian for an incapacitated person under Chapter 190B, Article 5, Part 3. That's my point. That statute gives the guardian certain powers, and subject to the limitations document. The limitations document refers only to routine health decisions. That's a meaningful word.
All right, now let's say I'm a judge and I've got a patient who is making poor decisions about antipsychotic medication, but great decisions about his cancer treatment. Really good ones. He's talking to specialists, he's getting the right treatment, it's going great, and he's very engaged in that part. But he won't take this medicine, it makes him feel sleepy or whatever, right?
Yes.
That he needs. Where would the judge check on this in order to say, oh, he can still make the decisions about his cancer treatment? I have no right to take that away from him. Where would I check?
Well, that could be part of the limitations document.
Where would I put it?
Well, the judge could add something to the limitations document. This is a form, and it's by no means has to be exhaustive. Here, the judge felt that these were the only limitations. I do want to make one factual point, and it goes to a question that Justice Henry had to Ms. Naring, which is, and I am going outside the record here because it's a subsequent event, but there is a new treatment order now that allows or that orders that the medication here be by oral form rather than injectable. So that that new treatment plan is.
But that's what he wants. So why do you need a guardian?
Well, that's it. Just because he prefers the oral form of the medication.
Why don't we put it a different way? Just because he accepts his doctor's recommendation and is taking his prescribed treatment, go on.
That doesn't mean that he's competent to make informed medical decisions. That's what Rod.
The only one this says he's not competent to make, so far as I can tell, is the one about antipsychotic medications. And I just don't understand how you even need this.
I think you're saying, because I'm struggling here too, is that the evidence that he couldn't make clear decisions about the lung issue bear on his ability to make other medical decisions, including on the antipsychotics, even if right now he's taking the medication as the doctor recommends. That's what your argument is?
That is my argument. There is some language in a case, this is in the brief, it's called In Re Leos, which talks about that there's sort of this inherent implausibility to the idea that someone can be sort of incapable or incompetent to make medical decisions generally, but be totally competent to make them around antipsychotics.
And that's an unpublished opinion,
but
and the statute provides.
Could I just hear the end of that argument?
I do think, the bottom line is I do think the situation with the lesion, the weight loss, it is probative of this gentleman's his competency to make treatment decisions. And I think that coupled with the fact that there was a point in time that the doctor testified where he stopped taking his medication. There's evidence in the transcript that he describes the medication as being forced on him. He said my psychiatrist was trying to take me off it, and then
When was that?
When was that?
Yeah, when? How far before trial?
It's not specified, but
more than 2 years, though, given the timing of the filing of the petition.
What he said was at the time that his new psychiatrist, his current psychiatrist, came on board, that doctor forced me to take these medications. I think all of this is probative of a lack of competency to make these type of determinations. And certainly there's not, I appreciate the court's questions, but I think there's enough evidence to support both the guardianship determination and the competency determination when the record is looked at as a whole. And I think the court is allowed to look at the full record.
I've taken a lot of your time, so I'm going to give you a little more time and let my colleagues ask what they need to.
So I just want to question this connection, though, between not seeking diagnosis and possible treatment of possible lung cancer. Because there's certainly, I don't know that we would take judicial notice of it, but there are certainly many, many people who've gone through cancer treatment who've said they would never do it again. And so if his position is, I would never do it once, like that's not irrational, and I don't quite understand how that connects up to the antipsychotic medication that he is taking. Right? It's maybe not a choice that I would make, but there are many, many reasonable people who would not seek cancer treatment. And so I'm not getting the connection there.
Well, that's a question for the trial court to decide. I think the trial court found that this dynamic as a whole around the lesion and the extreme weight loss and then this sort of outright refusal to do any further investigation, this was sort of emblematic of a larger sort of lack of competency to...
Well, but I know, but then I'll go back to Judge Rubin's point, which is if that were the standard, a huge percentage of people in this country would be under a guardianship. Okay. People who are refusing to confront a medical problem...
I think there's much more to this case, Your Honor, in the sense that there was an expert that testified. And this was in the guardianship of AR decision, which is published. There's discussion of the fact in that case there was an expert who testified who was the psychiatrist. Here there was the psychiatrist who met with him. And I think that person's judgment and opinion is entitled to weight. When that individual says, I met with him weekly for every 3 years, and this gentleman, his mental illness does affect his both his insight into his own mental illness and his judgment around all these decisions. And I don't...
But we don't care enough about his physical health and the possibility that he has a terminal illness to ask for anything about that. But we do want to make sure that we can give him an injection instead of a pill. So could you sign this order, Judge?
I think that's a totally unfair characterization, with all due respect, because, again, the guardianship appointment covers by statute, by law, this broader scope of responsibilities. So it's not as if in this...
And would there have to be a treatment plan? I mean, if I look below at your prayer for relief, I have a funny feeling I'm going to find that you asked for a guardian for purposes of giving him antipsychotic medication if he didn't want it. That's my guess. My guess is your prayer for relief wasn't. And so we can get him right in for those tests that we think are urgent.
I don't think that's true. I can't say that for sure.
I'll look, of course.
There was a broader request to have a guardian appointed.
No, you don't have to look at it. I mean, it says whatever it says. I just find this a really odd case. It seems like the tail is oral or injected Haldol, and the dog is lesion and 110 pounds of weight loss. Right?
Can I ask one question before we wrap up? Could I just ask counsel, and I think maybe you were going to this earlier and we didn't get there. Can you quickly summarize for me, beyond the cloudy thinking around mental health decision-making, the questions about the lung lesion, which as far as I can tell don't have any direct connection to cancer in the record. Am I right about that? Is there any diagnosis in there, at least to this point, or is it the argument we don't have enough information to get there?
The argument is that he's refused further treatment or study of that question.
Beyond those things, what is the evidence that's not listed in the judge's findings but supports it?
I would say a couple things. The doctor testified that this gentleman has poor insight into his own mental illness. In other words, he doesn't accept the fact that he has a mental illness. And that is demonstrated in the trial testimony where he says, I understand that I've been diagnosed with a mental illness, but that doesn't mean I have to agree with it. Now, one does not say that, certainly in open court, unless you have serious doubts about your own mental illness. So I think that's one thing. There is evidence in the record that he stopped taking his medication, and I accept it's not, the exact timing of that is not defined, but he stopped taking it, and he lapsed into what was described as very psychotic and delusional behavior. Again, I think all of this goes to the question of incapacity and incompetence. And I still think some weight should be given to the fact that there was expert testimony by his own psychiatrist, who he meets with once a week, who says, I have concerns about how the mental illness affects his medical decision-making. So I'll stop there.
Thanks.
Unless there are further...
No, this is
Okay. Very helpful arguments from both sides. Thank you very much. Obviously, this is a case of serious concern to us, so we appreciate your assistance with it.